Good afternoon and welcome to the September 15th, 2020 special meeting of the Glendale City Council. Due to evolving situation with COVID-19 and health recommendations from LA County Health Department, the Glendale City Council meeting will be available to the public electronically. Due to social distancing requirements, the public will not be able to attend the meeting. This meeting can be viewed on local cable Charter 6 and the Spectrum Charter 6 and AT&T Uverse Channel 99. You may also stream online through our website www.glendaleca.gov by scrolling all the way to the bottom of the web page and selecting live streaming, which is the third icon from the left. For public comments and questions during the meeting, call 818-937-8100, which is on the screen on top right. Please don't call in advance of the agenda item. With this being said, may I have roll call, please?
Councilmember Brotman.
Here.
Devine.
Here.
Kasakian.
Here.
Najarian.
Here.
Mayor Agajanian.
Present. Thank you, Mr. Ajamian. What's next, please?
The agenda for the Tuesday, September 15, 2020 special public meeting of the City Council was posted on Tuesday, September 8, 2020 on the bulletin board outside City Hall.
Thank you. What's next, please?
1, community development regarding review authority for Mural, a motion providing direction to staff.
Thank you. Ms. Yasmin Beers.
Yes, Mayor Agajanian, members of the City Council, good afternoon. We have Ms. Zemetitis here, our principal planner, who will provide you with a presentation related to this item. Delia?
Yes, thank you, Ms. Beers. Council members, thank you as the PowerPoint comes up. Staff is presenting a report on murals, specifically the Design Review Authority, and also a few standards at the request of one council member who wished to reevaluate who reviews murals in the city and how the process is conducted. So murals are actually defined in our sign code. The definition is on the screen, but I'll read it out shortly. Mural means a sign consisting of a picture, painting, or other artwork applied to and made integral with the exterior wall surface of a building, structure, fence, or garden wall, and which contains no copy, lettering, symbols, or any references directly related to the promotion of any product, business, organization, service, cause, or place. Again, this would be murals on private properties, and these would only be permitted in commercial and in industrial zones. Murals currently are not permitted in residential zones. The zoning code requires design review of all murals, and the current authorities are as follows. In the central business district, or I should say in the central Glendale redevelopment area, murals are reviewed, in this case by the City Council after the dissolution of the Glendale Redevelopment Agency. This is still in code and will be cleaned up as part of the design review amendments coming before you at the end of October. City Council reviews all murals for new buildings and for additions to such buildings in the DSP that are greater than 10,000 square feet. The Community Development Department Director reviews all other murals that are located in the general downtown specific plan area that are for buildings that are not new or for additions that are less than 10,000 square feet. And the Design Review Board reviews all of the murals throughout the rest of the city. The city manager does have the ability, per the administrative policies of the city, to exclude murals, and specifically those regarding city projects, from the design review requirement. And just to note that the current Design Review Board fee, the application fee, is approximately $3,800, and that would be $3,840. This would be irrespective of which review authority is reviewing the murals, whether it be City Council, Design Review Board, or the Community Development Director. If the mural goes before the Arts and Culture Commission, just note that there is no fee at this time. Current mural standards, and this is in the zoning code, specifically the Design Review Authority has to review the mural on 6 standards. First one being that it shall not contain any letters, numbers, or symbols that constitute any form of advertisement or commercial message, so it cannot be commercial in nature or with any type of lettering. That the mural not contain any obscenities. The mural shall not detract from the architecture of the site or the surrounding area, and this we'll get into a little bit further in the PowerPoint presentation in terms of a discussion of architectural compatibility. Fourth standard would be that no landscaping be removed as part of the installation of the mural, that the mural be very durable and capable of being well maintained, and the last, that the mural be placed on an existing wall. You would not be able to build a new wall and install a mural. It would have to actually be an existing building wall or fence. Staff would also like to use this time to point out some considerations. The First Amendment, the freedom of speech, actually precludes any type of design review authority from discussing and conditioning the content or the viewpoint of murals on private property. So you would not be able to put conditions or speak to the actual mural representation or the content of the mural. And then also we would like to point out that the architectural compatibility standard that was just mentioned in the list is a rather subjective standard, that the, whether or not a mural detracts from the architecture or the site or the surrounding area is somewhat subjective by its very own nature. So that is a standard that staff at this point is recommending be eliminated from the list. In terms of other cities, City of Burbank actually looks at murals as if it would be a wall sign. So long as you meet the wall sign standards, you would be permitted and approved for a mural. Cities of Pasadena and Santa Monica both do not regulate murals, so long as they do not have lettering or some sort of commercial advertisement component to it. And the cities of West Hollywood and Los Angeles both have very comprehensive, robust mural programs. These programs are actually run through each of the various arts departments. In the city of West Hollywood, it would be the arts division. In the city of Los Angeles, it's the cultural affairs division. City of Los Angeles requires that all murals be registered. City of West Hollywood actually has a design review authority through their Arts and Culture Commission. They have a list of muralists that are permitted by right, and it's a rather extensive process. I'd like to also point out that both of these cities also have a rather significant staffing component to both of their arts divisions that are reviewing these type of applications. In terms of options before City Council, going back to the original request to review who is the design review authority and the appropriate one that is, City Council has the option to have all design review for murals in the DSP go to you specifically, and to have all other murals outside of the DSP go to the Design Review Board. Another option would be to have all murals citywide, regardless of whether it's in the DSP or in other zones, go before the Design Review Board. Next option would be to have the Arts and Culture Commission review all murals. And again, I'd like to point out that the Arts and Culture Commission at this point in time does not have any application fee, whereas the other reviews do have an application fee. The last option would be to have the Community Development Director, and this would be with input from the Urban Design Studio staff, review all murals. And this would be much more of an administrative process. So provided that a mural application meets the 6 or amended 5 criteria that staff just went through in the mural sign codes chapter, it would essentially be approved. Given the fact that it would be a much more simplified process before the CDD director, staff is recommending that the application fee be reduced for an administrative review of murals. council at this point in time would also have the option of amending any of the 6 criteria. And again, staff is recommending that the architectural compatibility standard be eliminated or amended. There is also a consideration whether or not City Council would like to see murals approved on other surfaces besides existing walls, and this is in regards to the upcoming city skate park proposal. And in this case, the surface would be a floor and not a wall. And the last consideration would be to add a timeline for murals. The proposed time limit in this case, what we have before you would be 3 or 5 years, and this would be eligible for renewal. This is to accommodate any changes in the building in terms of renovations or in an art program. I'd like to also point out that the City of West Hollywood actually has a 1-year time limit on their mural approvals. So this is consistent with other jurisdictions. That concludes staff's presentation. I know there were a number of questions regarding the First Amendment issues, and the legal staff, Ms. Jillian Van Meiden, is here to help answer those as well. I'm available to answer any questions you might have regarding the actual mural process and the review authorities.
Thank you. Ms. Van Meiden, are you adding something to the? Oh. Okay. Do we have any callers?
Mayor, we do have 2 callers.
Okay, let's go to the callers, please.
Sue, you're live. Sue?
Hi, my name's Sue Bell Yank, and I am a Glendale resident, and I'm also a commissioner on the Arts and Culture Commission. And I really applaud the council for taking up this matter. I think it's really important. Murals are one of the oldest form of public art and public artistic expression, and they're often not just initiated by businesses or commercial entities, but also by neighborhoods, artists working in collaboration with community groups, schools, etc. And I think all of those stakeholders should have the benefit of this form of expression. I do think about the murals in the city of West Hollywood or in Santa Monica, as staff has spoken about, and how they can be really iconic and a major attraction for visitors. And so I think that by limiting murals to the commercial and industrial districts and by categorizing this form of public art as signage, the city of Glendale really is effectively limiting an entire form of artistic expression and making it less accessible to Glendale's diverse neighborhoods, schools, and communities. It's not signage, and I think it should be subjected to different standards and review processes. And since Glendale already has a body of arts professionals, the Arts and Culture Commission, that is meant to have jurisdiction over the selection of public art, I do think it's common sense that the review process for murals be entrusted to this body. And in fact, the Urban Arts Plan, which Council unanimously approved, recommends that the Commission have jurisdiction over the review of public art and review the standards for murals as well. And I just believe that all art should be reviewed and coordinated holistically by this body that, would effectively be able to streamline it as a process and not have different forms of public art emanating from different departments in the city. So I'm hopeful that you will vote for the process alternative number 3, to have the Arts and Culture Commission review the murals and actually take a look at the standards to come up with a more comprehensive kind of mural plan similar to what the city of West Hollywood has. Thank you so much for your consideration.
Thank you. Next caller.
Arlene Vidor, you're live. Arlene?
Reviewed and coordinated holistically.
Arlene, can you hear me?
That, would effectively be able to streamline
Arlene?
it as a process and not have different forms
Arlene Vidor, you're live?
from different
Hello?
departments in the city.
Yes, you're live. Go ahead,
I'm
Arlene.
hopeful that you will vote for the process alternative.
Can you lower the volume
Yes,
on your TV?
There's a little delay, and that's why I thought I wasn't on yet. Good afternoon, Mr. Mayor, council members, and city staff. My name is Arlene Vidor. As a resident of Glendale, I've always been very interested in seeing a strong mural program develop here. Mural programs have been adopted, as Ms. Yang said, by so many visionary cities in our region, as well as nationally and globally. And that's probably because murals are one of the most universally appealing and accessible public art forms, and they really have a magical democratizing impact on communities, especially when there is ethnic and cultural diversity. And I've experienced this feeling in other places, but not yet in Glendale. I strongly support alternative number 3 because the Commission has been tasked with oversight of the approval of art on the public right-of-way and also has been charged with developing a mural ordinance, among other policies and guidelines for public art in our city. And of course, I too got that right out of the pages of the Urban Art Program Plan under the implementation grid. You can find that on page 50. I also see the development of a citywide mural program in and of itself as a means to bring the community together to develop our public art program plan further. There are so many talented and very qualified individuals in this town, and there's no reason for us not to consider reincarnating the Urban Art Program Plan Advisory Committee, maybe as more of a multidisciplinary team that could work to bring the program up to date as they brought the program in 2017 and 18. And finally, and personally, as an Arts and Culture Commissioner, I have to say I feel very fortunate to be working with colleagues whose passion, knowledge, and expertise I deeply respect. So I hope that you can put your trust in the commissioners that you have appointed to do the job that we've been tasked to do by you, our City Council. And I thank you so very much for letting me speak.
Thank you. Next caller, please.
Mayor, that was the last caller.
Oh, okay. This is our special meeting, and I just want to go to my colleagues if they have anything to add or comment on this item. Anybody?
I have
Ms.
some
Devine?
I would like to ask, this is Councilmember Devine, Ms. Van Meiden, how does Pasadena and Burbank allow murals in residential areas, zones? Or Veolia, either one?
That, I don't have an answer for that question because I did not, I haven't taken a look at their code, but we can certainly try and pull it up and get an answer to that before the end of the meeting.
Veolia, do you know?
I know that the city of Los Angeles actually prohibits murals in residential zones except for certain historical districts, so it would be in a very limited area. I know West Hollywood does allow for murals. They would have to go through a separate process in residential zones. We would need to look up Pasadena's and Burbank's at this point in time. And I believe Ms. Beers.
I just sent a note to the CMs to say.
Thank you.
Okay.
So yes, we will have that answer for you shortly.
Okay, great. And my other question is, how does West Hollywood and well, I guess other cities handle this First Amendment? You know, one of the standards is that murals shall not contain any letters. And I'm sure the First Amendment supersedes that. So how do we handle the First Amendment with the possibility of what could be painted on houses and garage doors and lawns and whatever else we do in residential areas?
Councilmember Devine, we've already taken a look at that issue, and as indicated by Mrs. Zematitis, we do have, our zoning does preclude painting murals in residential zones. So currently they're permitted in commercial and industrial zones. So that addresses that component of your question. The other issue is whether or not we can regulate other forms of, quote, content. That would be symbols, letters. The jurisprudence in this area, the highlight of the jurisprudence in this area is that if you have to look at the sign or the mural to determine whether or not it is one or the other, you're examining content. And so if you're regulating on that basis, it does raise a First Amendment concern. If it if you do want to regulate what is on the content of a sign or a mural, then it must pass strict scrutiny. In other words, the regulation has to advance a compelling state interest, and it has to be narrowly tailored. If it is just based on content neutral time, place, and manner restrictions, such as a location on a wall, a size of that location, say 200 square feet or 1,000 square feet, or the time that it can be displayed, such as 3 or 5 years, or related to when building demolition might occur. Those are content neutral types of regulations, and they're subject to what's called intermediate scrutiny by the courts, a lower level of scrutiny. And it's possible to regulate time, place, and manner where that advances a substantial governmental interest that's unrelated to the speech. And it's not overly broad, and there are ample alternative avenues of communication. So with respect to regulations of signs, usually it's traffic and aesthetics that are the two issues, the two regulatory factors that come into play. And so time, place, and manner can be imposed to advance what is a substantial government interest in protection of people from concerns related to traffic distractions and the related aesthetics, as long as the content of that sign or mural is not being regulated. So that was a quick nutshell on the standards that get applied. So if it's content, you look at it very strictly. If it's not content-based, if it's reasonable time, place, and manner restrictions unrelated to content, then municipalities, cities, regulators have broader discretion to set those standards. Hopefully that gives a framework in which the regulators need to take a look at it. But if a regulator has to look at the actual sign to determine whether or not it's conveying any kind of message, symbolic or otherwise, and the regulation is based on that, that's a content-based regulation.
Councilmember Devine, this is Vilya Zematitis. I would just like to also add, in speaking to the Public Arts Administrator for the City of West Hollywood earlier today, she actually mentioned that the mural program for West Hollywood is being reevaluated because they do have criteria that are both subjective and objective. So they are actually working as we speak with their city attorney to reevaluate that, and they said that in perhaps a month or two we would be able to take a look at their new and updated mural program. So if that is under for your consideration as well, if you have that question, why do they get to do this and why can't we? That is actually being reevaluated at this time as well.
Okay, and my other, let's see, if we put this solely on the Arts and Culture Commission for approval, then council really doesn't have anything except a subjective reason for, denying. So we would be kind of out of the loop, because the Arts and Culture Commission would go by the standards, and if it came to council, the standards would have already been met, already okayed, and so council would only be, if all we had to say was, I don't like it, that kind of negates council. So if we give it to Arts and Culture, I guess what I'm saying is that it wouldn't need to come to council.
Councilmember Devine, that's not necessarily the case. If the objective standards were misapplied, that would be a basis upon which there could be an appeal to council, and that would be considered by council to determine whether or not those objective standards had been appropriately applied.
Okay, so they can, of course, they can appeal. Okay, those are my questions. Thank you.
Thank you. Mr. Patakian?
Sure. I actually have a question, and then I have some comments, but I can wait to hear from my colleagues. Is the restriction or the letterings and numbers limited to the advertising caveat only, or is there no circumstances under which lettering can be allowed?
Currently, the way that the code is written, Councilmember Kasakian, no lettering is permitted. But again, that would be up for interpretation whether or not that's a freedom of speech limitation that is dealt with in terms of the First Amendment issues. So
I mean, in terms of developing a guideline, I would say that, most artists like to sign their, nom de plume, their name to their work. And if that's going to be a violation, it just seems, from a common sense perspective, it just seems silly. So we ought to figure out how to address that.
Councilmember Kasakian, I believe Mr. Lanzafame is coming to the podium, but I would imagine for a signature, we would probably permit that because it is the signature of an artist.
And I know that we will, but just so there's some clarity. I mean, ultimately, what I hope that we do today is ensure that whatever statement of purpose that we come up with for the regulations regarding these murals will clearly explain the justifications, the goals, and the objective of whatever our legislative decision-making process here is and in the near future. Mr. Lanzafame.
I was just going to say, the language, it's a little bit ambiguous. It could be interpreted to mean that lettering that applies to or suggests a commercial message is prohibited, but otherwise it's not. Practice has been simply not to, although I think several years ago at Venice Hospital, they had the word love on a mural. Certainly, if it's the council's wish to limit it or to prohibit it just to commercial messages, tell us and we'll include that in whatever comes back to you and make sure that we're applying your intent. If you don't want to have any lettering at all or any numbers at all, let us know that too. But if it is your intent to allow certainly the signature of the artist or even the lettering or numbering as part of the art, let us know that. And we can clarify that with the language that comes back.
Okay. I just want to get this stuff out there. I want to have it be out there in the ether so we are aware of it, and then we don't come up with something after this exercise. And I know that council has gone through this a number of times in recent memory, so I'd like us to have some clarity. I do appreciate staff's research into this and keeping us up to date into what other cities do. Certainly it's a challenge to decide what we may like individually or collectively. What constitutes art is subjective, and what constitutes good art is even more subjective. It varies from person to person. So I don't wish myself or my colleagues to be the ones making those decisions. Ultimately, I do want the Arts and Culture Commission involved in this process, much like we, and in terms of what is out there and what we approve or what we don't approve, one of, I think, the most successful programs that staff has implemented that we see throughout the city is the utility box art program, none of which I think have ever come to council for approval. And I don't think in the past we've ever had anything that's been deemed inappropriate or inflammatory or commercial. I think it's been a greatly successful program. I would like to recommend that staff also look at Savannah, Georgia, which did an extensive study of, I think their study was called Graffiti versus Murals, and Savannah being a city steeped very much in its history and historical neighborhoods, and what they went through to come up with a program that allows for their murals. I do believe that murals create a public value in terms of art. It helps create cultural identity, it helps even maybe preserve history, it promotes economic development and revitalization. It's something that communities can really come around. We've seen it in various places in various ways. It helps people foster, it helps us engage with the communities as well if done correctly. Ultimately, why I asked for this issue to come back is because I feel that the $3,600 fee associated with an approval process is extremely prohibitive. Just the materials alone for creating a mural are very expensive. Art materials in general are expensive. And on top of that, we saddle individuals with this $3,600 fee, which is, I think, it's prohibitive. There's really no other way to describe it. Lastly, in terms of what is allowed and what isn't allowed, I do want to remind my colleagues that You know, right now, our schools all have murals. They have murals promoting their name of their schools and their mascots, and they have lettering. And guess what? There's nothing that the city council can do about it because they are exempt being an educational institution under California law, and I'm fine with that. Go Nitros, Tornadoes, Panthers, Dragons, everyone else, Falcons, sorry, Phil. So, you know, I think that we shouldn't allow ourselves to be dictated by our own fears as to what may or may not happen. Let's look at what some of the other cities have done, and I do want to see the Arts and Culture Commission be involved in this, because certainly I don't want to be the one sitting up here rendering judgment on what is art and what is good art. Thank you.
Thank you. Mr. Najarian?
Thank you. Thank you, Mr. Mayor. So I really like murals. The idea to paint those utility boxes was mine back from 2008, if I'm not mistaken. So I very much enjoyed murals, and I want to be part of the process. I mean, to be honest, I think it's a stimulating process. It's very exciting, perhaps getting to work with the artists and understanding their concept. So I don't want to be left totally out of the loop. I'd like to be in there somehow, maybe working in coordination with the Arts and Culture Commission. I just would like to be part of that. We're not all dry, bureaucrats up here on council. Some of us have an artistic side. All of us do, whether we know it or not. But I have a couple questions about the criteria. I mean, this is a kind of a slippery slope that we deal with. How about a Kobe Bryant mural? Wearing a Lakers jersey, number 23, Bryant, and all that. Those are numbers, those are words. We would say that would be inappropriate.
Councilmember Najarian, in terms of a Kobe Bryant number 23,
Lakers uniform.
Now, that would be not advertising a commercial entity. It would not be a cause, but again, I'm looking to Ms. Van Wyden. According to our code, the strict application of our code, it would be prohibited. Whether or not under the First Amendment rights, an individual could propose such a mural, that would be up to the city attorneys to opine.
Thank you, Councilmember Najarian and Ms. Zematitis. And both of you raised the exact issue that the courts have been grappling with when it comes to mural jurisprudence and looking at signs. And it is it's a virtual Tower of Babel out there in determining what is or is not commercial speech versus artistic expression. So if that mural of Kobe Bryant were just simply on the side of a office building, is that commercial speech? What about if it's on the side of an office building that has a big 5 on the bottom of it? Does that now become commercial speech? And it is now subject to greater scrutiny under our code because we don't allow it to be related in any way to a commercial venture. That raises the issues of whether or not the content of a sign or a mural can be regulated in that way. So we have to, and this is what our intention is, and at least legal's recommendation is that we are going to take a closer look at these standards within the current spectrum of the jurisprudence and the application of First Amendment standards. What are content neutral, reasonable time, place, and manner restrictions for these for murals and for commercial signage? The current jurisprudence is moving in the direction of that line is really blurred. And that was a very good example to show how the line between what is commercial and non-commercial speech is becoming blurrier as time moves on and the courts are beginning to recognize that. And that's one of the reasons why I believe that the city of West Hollywood is taking another look at their standards in light of more recent cases, in light of the Reed versus Town of Gilbert case, and an examination and understanding of what in fact constitutes content neutrality in the evaluation of signs or murals. So we are going to take a closer look at that, and we'll be working with planning to ensure that the standards that come back that would be recommended adhere as closely as they possibly can with the current status of First Amendment review of these matters.
And so that was an easy one. That was a very sympathetic figure whom we lost in January. Let's go to the other extreme. Let's go to a very vile and offensive mural. Let's say a swastika. Someone wants to put a big swastika up. What control do we have, whether it's the Arts and Culture Commission or Council, to prevent that?
Again,
substitute your own vile image, whether it's a communist flag or we all have our own demons, right? So I think the swastika perhaps is something that's universally loathed. We couldn't, according to your discussion, we couldn't deny that because it would be based on content if we were to deny it.
That is correct. The same would hold true for any other acronym or logo, such as Black Lives Matter, or depending on where you are in the United States, whatever, a Confederate flag or an American flag or a Nazi swastika. Any of those symbols might be offensive to some, not offensive to others. And that is political speech. It's protected under the First Amendment. The issue also deals with whether or not it would incite immediate danger or harm. So that is one of the issues that we're always examining in terms of speech, whether it's it might be offensive to some, but are they quote unquote fighting words? And would it result in a immediate threat of harm? So it's a very difficult balancing test. Those expressions are protected under the First Amendment. It makes many people feel very uncomfortable. That is true, but we would have to examine those issues on a case-by-case basis.
And my last comment would be I would support a reduction in the review fees from that $38.40 down to something reasonable. Thank you, Mr. Mayor.
Thank you. Mr. Broughton, Councilmember Broughton.
Let's see. Let me ask a couple questions first before I give comments. So the utility box program, we have letters and numbers on those utility boxes, or no?
Actually, it appears that we do not have letters or numbers on the utility boxes according to the program, but I'm going to ask Mr. Gary Schaefer, the director for the Parks, Library, Culture, to answer that question.
Gary Schaefer, Director, Library, Arts, and Culture. Mr. Mayor Agajanian, Councilmember Brotman. I will not say that there are no numbers or letters. We prohibit artists from signing their boxes, though some have snuck it on there or put like a Twitter handle, but they're not supposed to do that. So there could be, as I think about the 100+ utility boxes, there could be a letter or number on one of them, but in general, as the ones that come to mind don't. I know there's one with say a fire truck on it that might have a station number or something like that on it, but as I think about it, none come to mind, but I'm not going to say that 100% none of them have numbers or letters on them.
But did we set that out as criteria, and more broadly, how did we go about approving those designs? If we did approve designs, I don't know how we did that.
So for the utility boxes, those are initially screened by staff, and then there's a committee of arts and culture commissioners who then choose the final selections.
So they are choosing based on content?
More or less.
Okay, and how is it that we can do that? if we can't do that with
We
Mural?
have a limited number of boxes, so we have to choose certain boxes, and we will choose a design that has children at a swimming pool will go next to the swimming pool on Pacific, at Pacific Park. We will choose murals. So I think it's more from a nature of we have a limited number of boxes, and so we have to pick something that goes with the flavor of the neighborhood. But good question.
Okay.
If I could add to that response, those are all also publicly owned boxes in the public right-of-way. And there's a different standard that can be applied there if it's considered government speech as opposed to on private property and the regulation of private speech.
Funded by the city.
They're funded by the city.
The artists are paid
And they're
by the
city,
city.
they're city-owned.
Okay, so as far as murals go, and I guess we don't consider those murals, right, on the utility boxes. We don't define those as murals.
We haven't considered them murals, but by definition of a mural, it's not, for the city of Glendale, we define a mural as on a wall. These are not on walls, but I think the general artist community would consider them a mural.
I have a question just about the way we define murals as signs. And this has come up in a number of letters that people sent in. What are the implications? What are the legal implications of defining a mural as a sign as opposed to just defining it as public art?
Councilmember Brotman, thank you for that question. It is a studied question. In fact, Mike and I have been reviewing a fairly recent law review article from the Benjamin Cardozo School of Law, and that is entitled "Art or Signage."
Excuse me, Mr. Van Meiden. Very sorry. When you speak, please speak to the microphone. Don't look at the speaker, because our viewers are going to have better understanding as what you are saying. So talk to the microphone, please.
Sure. Thank you very much. And I'll just repeat my response. So that issue concerning whether it is a sign or it's a piece of artwork is a recent topic of discussion, and in law review articles and certainly in cases. And at this juncture in the evolution of the jurisprudence, looking at First Amendment free speech and looking at how it's applied to the regulation of artwork or murals as opposed to signage, the concern is always whether or not there's an examination of content. If a regulator has to look at that mural or a sign to determine whether it's one or the other, that raises the specter or the concern that content is being used to distinguish between the two. And in light of that, the trend is, and also the guidance is, to simply use the same type of time, place, and manner restrictions, regardless of whether or not it's considered a sign or a mural, for purposes of protecting a jurisdiction from a challenge as concerning whether or not the regulation is content neutral. And there is broad latitude within the context of time, place, and manner to impose those types of regulations. So size, time, duration, manner, and that is where we will be taking a closer look, and we will be coming back concerning what does architectural compatibility really mean? If that can be married with an examination of the manner in which a sign or a mural is being applied to a wall, then there is some content neutral latitude within that context. And we want to take a look at that to enable, whether it's the Arts and Culture Commission or the City Council on Appeal, depending on the direction concerning the authority, so that there is some objective bases to determine whether or not that mural or that sign is passes First Amendment or constitutional muster. So hopefully that provides some context in response to the question concerning, is it a sign or is it a mural? I will add one more thing, and that is many cities do, many of the cities that were surveyed, at least in this particular law review article, do distinguish between what is a sign and a mural. So that's something that we will take a look at as well, whether or not we want to change our definition.
Thank you.
Okay, and actually, just as you were answering that question, I got a text with a picture of a utility box that says, "You cut this." So I guess there definitely are words on our utility
Apparently, I
box.
stand corrected.
But anyway, yeah, what I'm getting at is it's confusing because I'm not sure with our public art plan. Are we also in the same position where it's going to be check the box and we can't consider the compatibility of an art piece with whatever the architecture nearby or the neighborhood or anything like that? I'm just having a hard time understanding, and I think this goes back to Councilman Devine's original question. I don't understand how we could be so limited when there are many, many cities out there that I think one of the callers said, these visionary cities that really promote public art and murals being an important part of the public art, and places where, people go and they go because they enjoy that kind of an environment. So it's really a draw. And I'm very puzzled and feeling like I don't understand this enough to want to turn this into a check the box situation if we don't have to.
Mr. Brotman, I think one of the things as we have this discussion is important to remember is that we're looking at two segments of art, if you will. There's our own commissioned art, the utility boxes, murals that we might put in a park, on one of our buildings that we do. And we control that because as the commissioning body, we can control and put whatever it is we want. It's really the regulation that we're talking about today is geared more towards what I'll call private art. It is definitely going to be visible from the public realm, but it is commissioned privately. And whether sign or mural, we can determine that. But we are limited in what we can say about that design that somebody commissions privately. If we're going to allow these, we're limited. And that's all we're saying. And I think all of the staff is in agreement that murals can be a very wonderful component of art and culture in a city. We just want to make sure that council understands the difference between what we commission, we being the city commission ourselves, and what it is that we're, quote, regulating from the private sector.
Right. Okay, and that's a good distinction. So I guess in terms of my comments, I'm finished, I think, with my questions, but I think like all my colleagues, I also am a big fan of murals and street art as well. I would love to see us do some of those things. I grew up in Philadelphia, and there's this big patch of street art in front of the Philadelphia Art Museum, and it was always a real draw. It made that area very exciting. So I'm a big fan. Some of the callers, people that wrote in, talk about, art being mural art being, accessible and democratic and the oldest form of public art and a draw for tourists. And I agree with all those things. So I definitely want to see what we can do to make it more prevalent in Glendale and bring artists in and remove roadblocks. I am in support of giving full authority to the Arts and Culture Commission. I don't really feel that I have the skills to be able to be weighing in on these kinds of decisions, and I think that's why we appoint, the best people we can to these commissions, and the Arts and Culture Commission is certainly, one of our outstanding commissions. So I would be comfortable with the sole decision-making authority going to the Arts and Culture Commission. I would like to reduce the fee to 0. But I would also really like to see the Arts and Culture Commission take up the issue of, best practices and look at some of these great cities, some of them near us, West Hollywood and Santa Monica, some of them like Philadelphia. Councilmember Kazaki had mentioned Savannah. I don't know anything about that, but look at some of the great cities and what they're doing with murals, and come back with a set of recommendations to us, maybe in the form of, an outline for a citywide mural program. And that's what I would, if I can make a motion, my motion would be to, empower the Arts and Culture Commission in the meantime to make all the decisions, but have them tasked with putting together doing some research and putting together a set of proposals that we can make our city one of these visionary cities as well. And I would add to that motion reducing the fee to 0. So that's where I stand. Thank you.
Thank you.
Mayor, can I finish with my comments?
Yes, Ms. Devine.
Thank you so much. I think it was mentioned by one of the commissioners that called in that having the Arts and Culture Commission develop some sort of standards or work with staff on these standards, that is in the urban art plan. Is that correct? On page, I think she cited page 50. Yes, page 50 of the urban art plan. If so, that goes right along with what Mr. Brotman is recommending. But I just want to finish by saying that I've always been a fan of murals. I've always been a proponent of them. I've supported them. I think they're important to our city. I think they tell a story. They can tell stories. They can mark a moment in time, just for instance, the Kobe Bryant example. And they give our residents an opportunity to show their talents as well. So I'm in favor of giving the Arts and Culture Commission the ability to review all the murals on their own. And I too would like to see them come up. I hope that legal is working with them to tweak the standards and even with perhaps with West Hollywood to see how exactly they're handling. I think the First Amendment rights is like the most important part of this, because I think I'm concerned about what people might put on their garage doors or their front lawns, or, if we have absolutely no control over First Amendment rights, there's no telling what we would be seeing. And that to me is a little bit concerning. I do know that there is a utility box in Montrose that has Montrose on it and street signs, and so I know that some of them do have lettering on them, but nothing offensive. They're all just fantastic. So I would be in favor of approving that Arts and Culture has the authority, and I would also lower or eliminate the fee for applicants. Thank you, Mayor.
Thank you. Do we have any calls?
We do not, Mayor.
No?
No.
Okay, thank you. I like murals, but I have questions now. Did we say that nobody can sign, even on private building, the artist cannot sign on it? Ms. Van Meiden, or?
Mayor Agajanian, council members, currently the code says no lettering. Now, the city council has the opportunity at this point in time to modify that, because you are more than welcome to change one of the standards that says no lettering, and you can exclude signatures of artists or any other type of examples that you might have. So that is something for consideration at this point in time, amending any of the 6 standards set forth in our design review chapter.
Okay, but because I have problem if they sign, especially on public building. It will be like a commercial advertisement for the person. So that's why I don't want to see that.
Again, Mr.
Mayor,
Mayor,
but-
Yes.
as a public building, you, city council, and your staff through you, we maintain control over that. We could barely say, no, a third party, you can't put a mural here, or we don't want you to put that mural here. You control that already as the owner of that facility. So that won't happen. Again, what we're looking for direction on is, how do you want to do the private commission of a mural? How do you want to regulate that? I think the public side of that Mr. Schaefer is responsible for, that ultimately is either the Arts and Culture Commission, if you empower them with that, or it's the city council. And so you can feel comfortable in that you control that because it's what you want to do. It's really where we're looking for direction here is that commission of private art, which we all support. I think Mr. Schaefer would agree with me that we all support that. It's how do you want to implement that? Not necessarily public that he's doing through his efforts, but private through private commission. And then where do you want that? Do you just leave it in commercial and industrial, or other places, which then has more considerations?
Okay, but still I have the problem. How about the person signs his name on it? Is that okay?
You know, again, as I said earlier, the code, it says that you can't use lettering, I'm paraphrasing, to convey a commercial message. And in practice, we've just said, no numbers or letters. If the council wants to allow signature, allow numbers and letters as part of the art, I think, and this was a public commission, I think it was a public commissioned mural, the Panera Bread sign on the side of their building on California. That has lettering on it. It says bread and bakery and things like that. You can do whatever you want, and we're asking you direction. At this point in time, council, tell us your vision for it. You want to allow lettering for that. You want to allow lettering for a commercial purpose. We haven't talked about it, but I wouldn't recommend that. But I certainly can see where letters and numbers, the artist's signature is appropriate in the art form.
Okay, I have did you want to add something to it?
Mayor Janian, no, actually, Mr. Lanzafame answered the question that there is a definite distinction between what is on private property and what is on public property. I know that there have been jurisdictions, I believe it's City of Downers Grove in Chicago, which due to a court case, they banned all murals because they did not want to have that distinction of, do we get into content? What are we approving? What are we not approving? So they outright prohibited all murals. In this case, when you open up, and I'm going to look to Ms. Van Meiden instead, when you open up the caveat of what type of lettering, what type of wording, and then it becomes a little bit more subjective in terms of content, and the issue of content neutrality comes up again. What's a signature versus what's an advertisement for the artist of the signature? So there is somewhat of a gray area that I would look to the legal to make that distinction.
Ms. Van Meiden, do you have anything to add?
Just very briefly, if you look at our definition of a mural, it currently prohibits copy, letters, symbols, or any reference directly related to the promotion of any product, business, organization, or service. So that goes to your inquiry, which is a muralist providing a service? And therefore, would their signature on that mural be prohibited? I think you might be able to read our current drafting to say, yes, it would be prohibited. So that it raises the issue of why we want to take a closer look at our definition of a mural. Our definition, should it be include a sign? Should we allow for a percentage, an objective standard, a percentage of lettering within it? So these are the very sorts of things we want to look at to provide flexibility for the reviewing body as well as the muralist who is trying to convey a message through their artwork.
Okay, next question I have is whether it's on private or public property, do we have any regulation as to size of the mural in relation to the wall?
Mayor Agajanian, no, there is nothing in code at this point in time in regards to murals on private property that would limit the size of the mural.
And that would be a manner restriction, a reasonable time, place, and manner restriction that we could impose. So it's the size, percentage of copy, the location, for example, facing a commercial street as opposed to
Right,
facing a residential district. Those are the sorts of content-neutral regulations that would pass constitutional muster.
But to the facade of where the mural will be, is there any?
Yes, that it would be a manner restriction, and as long as it's reasonable. The cases that I've read, it certainly is within the realm of being reasonable that a mural is something that pedestrians or people visiting an area would want to be able to observe. So it would be a reasonable manner restriction to require that that mural be located on a wall that's facing a commercial street as opposed to on the rear of the building, that it would be restricted to a certain size or within a certain parameter, it not cover windows, for example, things of this nature. Those are reasonable manner restrictions that could be imposed.
So if I want to put a mural on a wall, on a facade of let's say my building or public building, so there is no percentage saying you can cover half of this facade of this building? So
Not
it can
today.
be entire the facade can be.
Not today. But if the council wanted to say 50% of the facade area or 75% of the facade area, you could, under time, place, and manner. You could do that.
Okay, thank you. And that was my questions. Is there any other question or comment from my colleagues?
I would like
Yes.
to,
Mr. Brock?
I have a
I'm sorry,
question.
Mr. Katsaki.
I'll defer to Mr. Najarian while I
Okay.
gather my thoughts, please.
So,
Mr. Najari.
so based on the motion by Mr. Brotman, the council has absolutely no oversight on any mural that's approved by the Arts and Culture Commission, or can it be appealed like a DRB decision is appealed?
That's correct, it would be appealable.
And can it be appealable by a council member? Let's say I don't like that swastika for whatever reason, and can I be the appellant? Or does it
Yes.
have to be a member of the public?
Yes, we have a provision within our code that would permit a council member to appeal it. City manager has appealed matters to the city council as well.
One thing I forgot to mention, I would like the city council to have some sort of control like before on DRB area. That's my desire, of course. Mr. Katsaki.
Ultimately, whatever we do to eliminate the fee, I think moving it to arts and culture would do that, so I would support that. Sounds like everyone has their own concerns. I would just only say that we should not be held hostage by our own concerns and fears, because we haven't had a rush on City Hall for murals or illegal murals necessarily popping up around the city. You look around the state, you look around the country, and for the most part, as I have observed, in my experience, it's been fairly well implemented. I mean, we don't want to be Beaumont, Oklahoma. That's a Footloose reference, by the way, for anyone who understands. We're not going to start regulating dancing and art and expression. In terms of lettering, if someone was to do the Constitution as part of their artwork that has letters, "We the People," if someone did a replication of Andy Warhol's Campbell's soup can that has letters and it actually is a product advertisement, but it's an iconic piece of American pop art, we shouldn't worry about something until we have something to necessarily worry about. As stated before, our utility art program, the utility box art program, has been a tremendous success. In other cities, it has lettering, and evidently here in Glendale, it does as well. So let's allow the artists to come forth, make their recommendations, go through the arts and culture process. If there's an appeal, I do like Councilmember Najarian's, the point that he raised, that a council member can request to have it come to council if there's something that should rise to that level. But let's also be aware that when it does come up here, we're gonna be held to the same standards as most of these court cases that have happened around the country have already established regarding free expression and art. And with that, if there's a need for a second, I'll be the one to second Councilmember Brotman's suggestion.
I'm sorry, a little bit earlier I said, I'm hoping that I said it right. I meant DSP zone. I might be mistakenly say DRB. In DSP zone, I would like to see that City Council have the last saying if it's needed. Okay, so where we are now?
Mayor Agajanian, just a little bit of clarification. I believe that there are 2 points for council's consideration. One would be the review authority, and if there is a motion to put the review authority in the hands of the Arts and Culture Commission as opposed to the different bodies that are spelled out in zoning code, that would be one item. That type of motion, if you would like to move it to the Arts and Culture Commission, we would be able to include that in the upcoming design review amendments going to be presented to you at the end of October as a follow-up to the DSP amendments, so for clarifications for the DSP. So that would be something that we would be able to include at that point in time, if you so wish, to move it to the Arts and Culture Commission or any other review body for that matter. The second item would be the actual mural component review standards, and if it is council's wish to see a more robust mural program, we would probably need additional time to bring that back and to actually work with both the legal, the arts and culture staff, and planning as well. So those would be 2 items for council's consideration.
And what about the fee? How about elimination?
The fee, if the city council chooses to have the Arts and Culture Commission review murals, at this point in time, there is no application fee to go before the Arts and Culture Commission, so that would be included then in the motion.
And finally, one other point that we would if it goes to the Arts and Culture Commission, the Arts and Culture Commission on their own art, their own commissioned art, are going to dictate what it is, and then it would presumably be approved. And you wouldn't need to have the policy question. If you want to have it with some other review body, we would suggest that the city manager get direction from you that they can go ahead and exempt that, because presumably it will have come from the Arts and Culture Commission, unless council wants to see it every time. And then the second item that we would like you to weigh in on is that for city projects, a mural doesn't necessarily have to be on an existing wall. It can be somewhere else. Again, the example coming up quickly is the skate park, where the mural will actually be on the deck of the park skate bowl.
And Mr. Mayor, I would be remiss if I did not let you know that one of the first mural programs we would love to consider is exactly in the DSP. So you may find yourself approving 10 murals if you want to approve. They would be arts and culture funded, and I don't know that there'll be 10, but that was one of the first programs we did want to look at. So if you want to weigh in on those, you may have many murals coming before you within, I'd say, the next, 8 months or so.
And if I may, Mayor,
Ms. Devine, please.
there's one at the YMCA as well, isn't there, that's coming up
Yes.
for discussion? So that's at least, 3 that we know of. Okay, thank you. That's all I
Thank
wanted
you.
to say.
Okay, now how we formulate this now?
Mr. Mayor, I think there's a motion and a second. I believe Mr. Kasakian did second Mr. Brotman's motion, and that was to transfer the authority to the Arts and Culture Commission, and there would be no fee associated with that. So that's the motion that's been seconded right now.
You mean the city council has,
It would come to city council on the basis of an appeal.
base of an appeal?
So if someone were to appeal the Arts and Culture Commission's decision, that decision could be appealed to the city council.
Including DSP?
There wasn't.
That's the motion.
Yeah,
And we as council members have the authority to do that as well.
Correct.
yes. But that would not exempt, I believe, Mayor Agajanian, your request was that for purposes of consideration of these matters within the DSP,
Right.
that the city council have original jurisdiction over that review. Is that, am I understanding that correctly?
Even if it goes to art and culture, eventually to come to us too.
So I think what I'm hearing is that for purposes of consideration of these matters within the DSP, that the Arts and Culture Commission would serve as a recommending body to the city
Right.
council for final decision?
That would,
The maker of
If
the
I could
motion.
clarify.
correct. That
Yeah,
would be the mo-
exactly.
I believe Mr. Brotman,
Mr. Mayor? Yeah, that was not my motion was that the Arts and Culture Commission would be the primary decision-making body. And yes, obviously, if there's an appeal, and I didn't know that council members could appeal, but that's fine, then it would come to council, but that would be on appeal, not as the primary decision-making body. So that was my motion. I also just wanted to clarify that I asked for something else, and we can split these up into two motions if you would like. But the other thing I asked was to task the Arts and Culture Commission, working with staff, of course, with Glendale Library Arts and Culture and with legal, to come up with a more robust murals program. And as part of that process, study best practices in other cities and study some of these legal issues. And I think in that process, unless we need to do it more quickly, we could have them cover this issue of other surfaces. And also, I know another issue that staff wants to discuss is the time limit on the mural. So perhaps Arts and Culture Commission, working with staff, could come up with that plan and address those 2 points. Unless there's urgency and we need to pull those and make an immediate decision, I'm open to that. But those were 2 things, and we can make them separate motions or we can make them one.
Mr. Brotman, I would recommend placing the time limit now, and then tasking, if you want, task the Arts and Culture Commission with reviewing that, and it can always be changed. The fear is that if we do, we're now talking about it and we're promoting murals, that we may run into a situation that Dr. Schaefer had talked about before in the interim. And so I would just recommend that you put a time limit on now. That can be changed as the Arts and Culture Commission is looking at a more robust program. And then I would also ask in your motion, if there is a desire to allow city-sponsored projects to be elsewhere than an existing wall. If that's your desire to include that.
I'm perfectly okay with adding those 2 points.
The timeline.
I have a question regarding that motion.
Mr. Najarian.
So we're going to task the Arts and Culture Commission to come up with a more robust set of standards. Will that come to council? Do we get to vote on that, or will they just make that up?
No, I would suggest that's a set of recommendations that council clearly would be deciding.
Comes to council.
whether to
Okay.
accept. Yeah, oh yeah.
Yes, that would have to come to the city council for ultimate approval.
And then, Mr. Lansfam, if you could clarify for me the timeline issue, what timeline do you need from us? What is for the duration of a?
So the recommendation is a time limit of 3 to 5 years. The mural could be renewed at that point. based on my own personal experience of a mural being in place for 30 years, people not even really noticing the mural, and then the owner of the building wishes to remodel the building, and the artist comes out of the woodwork saying, "What about my mural? What are you doing?" And there are certain rights that a artist does have under the Visual Artist Rights Amendment. So I would just recommend that we put a time limit on murals of 3 to 5 years, and then of course that could be renewed as that time expires, or the mural could be painted over. Just highly recommend it, had that come up twice on a project.
I'm fine with it. I'm just thinking of very famous artists who started off as muralists, and now their artwork's gone when a building got demolished, and you just read about the art that was lost, including Diego Rivera and a number of others. But yeah, 3 to 5 years is fine. Is there a preference? I mean,
I think we'd prefer, I guess we could cut it down the middle and say 4 years. It's rather arbitrary, but somewhere in the 3 to 5 year range.
If I might just add a point of clarification, that's currently would be a recommendation that would have to come back as part of the code amendment standard. So as soon as we are able to formulate that and work with the Arts and Culture Commission, depending on the council's direction, we would bring that back as part of the package of the regulatory standards before the city council for your approval.
Okay, about this 3 to 5 years, I agree with the idea because it can be forever. As you mentioned, the artist will come back and complain or sue the building owner. But 3 to 5 years, why we are saying 3 to 5 years? Why we don't say a certain fixed?
Well, so the recommendation would be 5 years.
Okay.
Let's just go with that.
Anything, 4 years, 5 years, but at least to make it clear that which one is it then? So 5 years, it's okay with me.
I would also like to make one other point of clarification. For purposes of a city council member appeal, that would come through the city manager's office. So the request would not, the request would go administratively through the city manager's office if appeal were brought to a Arts and Culture Commission decision. So just for point of clarification, administratively.
So again, so if it's going to Arts and Culture Commission,
If it does.
in DSP area, is that going to come to city council members?
Not the way that the motion has currently been made, unless Councilmember Brotman wishes to request an amendment to his motion, which would need to be seconded, to add your recommendation or suggestion that for purposes of the DSP, that the Arts and Culture Commission would be the recommending body, just for purposes of the DSP, but with a final decision maker to be the city council.
Like before?
That was not my motion. I would not support that.
That is not that's correct. The current motion is that jurisdiction over the review be with the Arts and Culture Commission, and it's been seconded by Councilmember Kasakian.
So I did, and I would just say that I understand your concern. So if there's, and I'm sure this is possible to do, when we receive staff reports all the time, can there be a period through which, when we review what's been approved by the Arts and Culture Commission, council then has the opportunity to review and maybe pull something off the docket
For the DSP? I mean, certainly, if you wish to do that.
So you would receive, if Councilmember Brotman accepts this, but for area and the DSP, we receive the Arts and Culture's approved renderings, and based on that, any council member can ask to have an item heard by the entire council for approval.
Okay.
I would, Artie, I understand where you're coming from, but I think we have that with the appeal. I would rather it go through the body, get approved or
Sure.
rejected.
I'm just memorializing it. I'm just memorializing it or stating it clearly so we all understand what the process is. So it's
But I
written
don't want
into
it to be, I don't want it to be something where it would get pulled before going through the Arts and Culture Commission.
No.
I think it should be on appeal.
It would be post arts and culture.
Yeah.
Any other comments?
I think that solves your, I think that addresses your concern, Mr. Mayor, is that if there's something that comes through you're not sure about or you want to run it through the council, then it can be brought up in that manner.
We can,
Okay.
that can be the way it's appealed or when it's appealed. Yeah. I
Thank
agree
you.
with that.
So everything is clear now to staff? Do we have clear direction?
Mr.
Yes.
Mr. Mayor, what I understand is that full authority would go to the Arts and Culture Commission, that the fee be reduced to zero, that city projects could be on places other than an existing wall, and then as something new or to be separately voted on, the Arts and Culture Commission be directed to create a more robust program for murals that would then come back to the city council. And the last point, 5 years, it would be a 5-year approval on the mural that could be renewable. Did I catch everything,
That is
Mr. Rock?
correct.
I think you got everything. Yeah.
But
Are you moving those, Dan?
Yes, I'll move that. That's the package I would like to move. Thank you.
no, but how the city council will be involved with this?
And then as, in two places, one, the Arts and Culture Commission would have full authority. Once they make a determination, the council any council member could appeal that. It would then come back to the council as an appeal in the DSP area. I suppose you could do it anywhere citywide. And then the second, the Arts and Culture Commission's review and development of a more robust mural program would come back to the city council. Those would be the two areas where you would have input.
Okay. Okay, roll call, please.
Councilmember Brotman,
Yes.
Devine,
Yes.
Kasakian,
Yes.
Najarian,
Yes.
and Mayor Agajanian.
Yes. So what's next, Mr. Ajemian?
Adjournment.
May I have a motion to adjourn?
Move to adjourn.
Okay, what time is
Is there
it?
a second?
Second.
Second.
Okay, what time is it?
3:26.
What?
3:26 p.m.
Okay.
26.
Okay, with that said, the meeting is adjourned at 3:26 p.m. Ms. Devine.
Okay, thank you very much. Good afternoon, everyone, and welcome to the September 15th